Hello, welcome to Workplace Wake Up. I'm Jen Shaw. Every week, I spend about 15 minutes covering key legal developments, introducing you to interesting guests, and providing some entertainment to start your workday. I hope you enjoyed this week's episode. Hello, everyone. Welcome to the podcast. I hope you had the most amazing Thanksgiving. We had a special treat this year because we usually go to my sister's house, which is always fun down in the Bay Area. And we ended up staying at home, so we got to do the Run to Feed the Hungry, and we cooked and cooked and cooked like mad. And my daughter made really cool apple pies, and our family was visiting, and we just had a great time. So I hope you guys had an amazing holiday. We are, of course, now in the month of the next big holiday for many of us, actually several important holidays for various folks in the world. So I just hope you guys have a wonderful month of celebrating with family. And then, of course, in January, we have more coming. So, there's just a lot to do and a lot to enjoy. So with all that nice news about family and turkey and the holidays, we're going to talk about a new wrinkle from the National Labor Relations Board. Now, you all know that we're going to have a new president in January. Incoming President Trump has very different views about unionization than the Biden administration. Having said that, the person he's suggesting for the Department of Labor position is actually very pro-union, which surprised a lot of folks. So it's going to be very interesting to see where all these cabinet picks end up. Why you care as an employer is because the board, the National Labor Relations Board, as you know, has been pretty employee friendly during the Biden administration. And that continued on November 13th last month when the board issued a decision relating to Amazon. And in that decision, it's called Amazon.com Services LLC. The board said, look, employers are going to violate the National Labor Relations Act, the NLRA. Remember, that's the law that was passed in the 1930s to protect union organizing, to protect union negotiations, to really give employees a fair shot to use the union as a real advocate for them, right? Now, these days, of course, we have the Civil Rights Department and the Equal Employment Opportunity Commission and very activist legislatures and all sorts of other protections. So in many ways, the unions have become less important in terms of ensuring employee safety, fair wages, that sort of thing. But unions are important for lots of other reasons, and many of us have belonged to unions in our lives. And some of you work, and I'm sure are responsible for union employees, work in union environments. So here's what the board said in this Amazon decision. They said, if you require your employees to attend what we call captive audience meetings, okay? By require, we mean if you don't attend, you could be disciplined, you could be fired. That is going to be a violation of the National Labor Relations Act, okay? Now, in reaching that decision, they overturned a 1948 decision they issued in a matter called Babcock and Wilson Company, in which they said, look, captive audience meetings are a really powerful tool to allow employees to share their views about union organizing and to share with all members of the bargaining unit that may be covered by a union contract why the workplace should remain union free. So let's back up the bus a little bit, guys. Most employers want to remain union free. Why? Because they don't want to have a third party involved in the workplace that they have to deal with. They want to be able to deal with their employees directly. So we're having an issue. I want to just go to the employee and discipline them. I don't want to have to deal with the union. Having said that, we have several clients that have very good relationships with their unions, and they have chosen not to fight the union efforts, but rather to work with the union. You decide that on your own, okay? You decide for your organization and your industry whether you're okay being unionized or you're not. I will tell you that the vast majority of employers would prefer not to be unionized, and a vast majority of employees don't want to belong to unions because they don't want to pay the fee, right? They don't want to pay the union dues. And they also want to have direct communication with their employer. So it's interesting, okay? There are definitely a group of employers out there that have unions, that work well with the unions. The employees are happy to be unionized, but most employers and employees like to remain union free. Okay. The reason that background is important is the Amazon decision took away a very important tool, as the board said, for employers to educate employees about the impact of unionization and why it is better for everyone, in the employer's opinion, for that workplace to remain union free. So anytime you become aware of union activity, potential union activity, so somebody says they were asked to sign an authorization card, you find out about meetings that are being held, you're going to want to be proactive about that. And one of the things you're going to want to do is hold a meeting and talk to everyone about why you want to remain union free. And that is what the board says you can no longer do. Now, just to be clear, it's not like this decision came out of nowhere. In April 2022, the general counsel of the board issued a memorandum, and she said in the memorandum, look, I'm going to ask the board to rule that these mandatory meetings where employers provide their outlook on unionization violate the act. They violate the National Labor Relations Act. And that's exactly what the board did in the Amazon case. They said that the prior decision in Babcock was poorly reasoned, and ruled that those captive audience meetings have a real tendency to interfere with employees' rights under Section 7 of the Act, which is the employee's right to engage in collective conversation and bargaining for their mutual benefit. What it really means is Section 7 rights are about whether or not you want to unionize, right? An employee has a right to join a union. They also have a right not to want a union in their workplace. Now, remember, once unions come in, it's going to be mandatory for everyone covered by that collective bargaining agreement. And that's something that a lot of unions don't focus on, right? Because employees like to have the ability to say, well, I know we have a union, but I don't want to join the union. It doesn't work that way. If the bargaining unit is subject to election or demand for recognition, and they are going to be represented by the union, then that is going to be a mandatory decision for everyone in that unit. So as many of you know, if you joined our legal update earlier this month, this is our 24th annual legal update. We cover all of the new laws and all of the new court decisions. We talked about California's captive audience ban, which is under AB 399. That law becomes effective January 1 of 2025. So it's just around the corner. And under that law, California employers can no longer discharge, discriminate, retaliate against, or threaten to carry out termination or discipline or retaliation if an employee refuses to attend a captive audience meeting. And the thing about the California law is the language of the statute says if the employer is discussing their views about politics or religion, including unionization. So California's ban is actually pretty broad. Now, what are the takeaways I want you to think about from these developments and these trends? And by the way, California is not the only state that's done this. We have Illinois as well, had their legislature enact a similar law. And then in Alaska, they just had it on their state ballot where they enacted this law, something similar. So key takeaways. First of all, the board said, and this is the case under state law as well, you can still hold meetings where you discuss your views on politics or religion or unionization, but only if the employees receive reasonable advance notice of the meeting. Attendance is absolutely voluntary. There are no potential negative consequences for someone who doesn't come, and you do not maintain attendance records. Okay, so really important. So obviously, the people who you want to talk out of joining the union are probably not going to voluntarily come to the meeting. They might, because they want to see if you're doing something wrong, right? As many of you may know, if you've gone through a union election, it's really just a battle of strategies and will and ideas. And so you may have a union supporter come to the meeting to make sure that you're following the law. Now, the good thing is the board also made clear, and this is, of course, the case with state statutes as well, that the new law, the new standard that the meeting must be voluntary, you must be given reasonable advance notice, and there's no attendance records. They're only going to apply that going forward, okay? Now, there's every reason to expect that the Amazon ruling and the California provision AB 399, probably also the Alaska law and the Illinois law are going to be challenged in courts. Because remember, we just had a very interesting United States Supreme Court decision, the Loper-Bright case, where the Supreme Court said you don't have to give deference to agency interpretations the way you have for the past 75 years. So, unlike the court's view before under what's called the Chevron doctrine, where they would give deference to the National Labor Relations Board's view on captive audience meetings, now they get to basically look at it from beginning to end. So they're not going to be bound by the NLRB's interpretation of what they think should be happening. Now, the other thing to understand is there's a preemption argument that will likely be made for all of these state laws. Preemption meaning the federal law occupies the field in terms of the National Labor Relations Act and unionization, so states cannot pass laws that impede or interfere with those rules. So we'll have to see what happens. Obviously, as I mentioned earlier, we've got a new president coming in. We're definitely going to see a new shift under the Trump administration. So even if the captive audience ban survives court challenges, which I think is unlikely, frankly, at some point, the Trump National Labor Relations Board is going to have a 3-2 majority, and we expect them to fully re-examine all of the pro-union, pro-employee decisions that have been issued by the board under the Biden administration, and probably will overturn them. So it is probably unlikely that the Amazon decision is actually going to survive the Trump administration. But until then, it's the law of the land. And of course, effective January 1, we've got the AB 399 law coming into effect. So you really have to be careful when you're dealing with potential union issues. Don't forget also that under the CMEX decision, which is a 2023 decision by the board, if you hold a captive audience meeting and it deals with union organizing and you don't comply with the 3 rules, right? That it's voluntary, that you don't take action, and that you give them notice, and you don't keep those attendance records. If you don't comply with those rules, you're going to have an unfair labor practice potentially. And what that means is that the CMEX decision says, well, the board can actually issue a bargaining order to make you start bargaining with the union, even though there has not been an election, because you violated the law. And the consequence of violating the law is that we're just going to let the union come into your workplace without you having an election. So I know there are some heady topics we've discussed here today, but folks, this is really important, and not just for union employers. A lot of folks believe that, well, I don't have to comply or worry about the National Labor Relations Act because we don't have a union in our workplace. Well, remember, a large portion of the act is focusing on employees' rights to unionize. So it becomes very important for employers that do not currently have a union, but whose employees may be interested in bringing one in. All right. So I know you've got a lot on your plate this month, lots to do, lots to shop for, lots of family to enjoy, but you got to make sure that you are getting ready for these new laws for 2025. And stay tuned. 2 weeks from today, we're going to do end of the year tune-up, where I'm going to talk to you about some things you need to definitely make sure you deal with by the end of the year and going into January. So until then, everyone, enjoy the holiday season wherever you are. I will see you back here next week. In the meantime, do something nice for someone and have a great day. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. If you enjoyed this episode and would like to spread the word, please share it with others, post about it on social media, and/or rate and review it. You can also follow us on LinkedIn, Twitter, and Facebook, and email us at info@shawlawgroup.com.